to meeting 140 as we continue our 5-year legislative review of the Copyright Act. Has it been how 5 years or the 140 session? It's been, yeah. It's almost done. We're almost down to the wire on this study. First of all, we have some folks with us today. Unfortunately, we couldn't be here earlier. We had votes, and that seems to take precedence over anything else. Okay, so with us today, we have, as individuals, Jeremy DeBeer, Professor of Law, Faculty of Law, University of Ottawa, Marcel Boyer, I can never pronounce that word.
Emeritus Professor.
Emeritus Professor of Economics, Department of Economics, Université de Montréal. Mark Hayes, Partner Hayes E-Law LLP, and then Howard P. Knopf. Do you pronounce the F?
Everything.
You pronounce everything? Knopf. Counsel Makera and tongue twisters today.
Sarah and Jarzina.
Jarzinia. All right. So we have lost half an hour. So if you have up to 7 minutes. Less is better. Gives us more time to ask questions. We do have another committee meeting here at 5:30. So oh, thank you so much for that. Why don't we start with Mr. DeBeer? You got up to 7.
Thank you very much, Mr. Chair, committee members. My name's Jeremy DeBeer. I'm a law professor at the University of Ottawa and member of the Centre for Law, Technology and Society, but I'm appearing here in my individual capacity. I offer this committee my own views, but based on my experience as former legal counsel to the Copyright Board of Canada and advisor to the Copyright Board of Canada, as well as to collecting societies, user groups, government departments, and international organizations. Over 15 years, I've designed and taught courses on copyright, argued a dozen cases on copyright and digital policy before the Supreme Court, and published extensively in this field. I'd like to mention specifically just 2 of my recent articles commissioned by the Government of Canada. One, a widely cited empirical study on the Copyright Board's tariff-setting process, which I did for the Departments of Canadian Heritage and what is now Innovation Science and Economic Development Canada. And another, a thorough review for ISED on methods and conclusions from evidence-based policymaking. And I cite these studies to emphasize that my views aren't based on special interests of certain industries or mere speculation, but on rigorous research that I hope will help this committee make some well-informed decisions. It's my 3rd appearance in about a week before a parliamentary committee. Last week, my testimony to the Senate Standing Committee on Banking, Trade and Commerce focused on proposed reforms in Bill C-86, the Budget Implementation Act, to the Copyright Board and the Collective Administration of Copyright. Yesterday, I testified to the Standing Committee on Canadian Heritage for its study on remuneration models for artists and creative industries, which will feed into this committee's review of the Copyright Act. I won't repeat that testimony, but I would like to highlight the most important points. First, as I told the Bank Committee, the resources and proposed reforms to the board and collecting societies are on the whole good, but there remains some important work for this committee to do on a policy level. To the Heritage Committee, I made the point that if artists have remuneration problems, the root cause may not be copyright at all, but rather power imbalances and unfair contracts with publishers and record labels and other intermediaries. I said that if the government wants to expand anyone's rights, it could start by recognizing and affirming that copyright doesn't derogate from Indigenous people's rights over knowledge and culture. And I think most importantly, that whatever the Heritage Committee and this committee recommends must take account of the dramatic extension of copyright protection in Canada's most recent trade deal with the United States and Mexico, the USMCA. So with that, let me turn to the statutory review of the Copyright Act that this committee is mandated to do. You do not have an easy task. I've seen the 100 briefs already submitted. and the list of 182 and counting witnesses you've heard from. Here's what I take from all of that. It's much too soon since the last round of amendments to consider any major overhaul of Canadian copyright law. In my view, the most important recommendation this committee can make is to get off the hamster wheel of perpetual copyright reform. It's not just pointless, it's counterproductive to reopen the Act every 5 years as Section 92 currently requires. And just looking at the list of special interest groups coming to you cap in hand makes one's head spin. The Act was modernized, that was the word, it was the Modernization Act, in 2012. Before that, there was a massive expansion of copyright in 1997. Before that, in 1989. How can anyone credibly claim to have evidence that the last batch of reforms is working or not? How can anyone say with a straight face that the Act is already out of date again? And these frequent reviews aren't free. They're cash expenses, there are opportunity costs, you could be focusing on other things, and most importantly, there are big policy risks. To be clear, I'm not suggesting that copyright's unimportant. To the contrary, it is a crucial issue. My point is that we need and we have technologically neutral principles, and we need the time to properly implement, interpret in practice and by the courts, and then consider the principles before giving lobbyists another kick at the can. And seen in that light, I think it becomes easier to discount a lot of the rhetoric and the recommendations around, to list just a few examples, statutory damages to coerce educational institutions into buying licenses they may not need or want, website blocking schemes or special injunctions to give copyright owners more procedural powers than other plaintiffs have, iPod or internet taxes or other cross subsidies, and on and on and on. Now, that said, there's one recent game changer, very recent game changer, that I think this committee should consider, and that's the dramatic expansion of copyright required by the USMCA. The USMCA will give copyright owners a full 2 decades of an additional monopoly. Copyright in Canada will soon last for the life of an author plus 70 years. On average, if you look at life expectancy, that's 150 years, a century and a half that we have to wait to freely build on and embellish works in the public domain. I understand why we did that. I'm a pragmatist. If that's what it took to salvage free trade in North America, all right. However, what it means is that Canada has now aligned the term of protection of copyright with the United States, but not the safety valves like fair use that are so crucial for driving innovation. Without counterbalancing measures to align Canadian and American copyright flexibilities, Canadian innovators would be at a huge disadvantage. In light of time, let me conclude with my general point on this. It's that for the theory of free trade in copyright-protected works to function in practice, both the floor and the ceiling of protection have to be harmonized. We can't take just the bad of American law without taking the good. And so my recommendation, above all for this committee, is to ensure that in any measures it takes, that it considers the changes that USMCA will bring in its report. Thank you very much.
Thank you very much. We're going to move to Monsieur Boyer. Vous avez 7 minutes.
Mr. Boyer, you have 7 minutes. Thank you very much for the invitation. I have a presentation. I'll try to stay within the timelines. The conflict between creators and users, of course, creators want to benefit from the value of their creations and that value that they generate for users. Whereas users want to minimize payments for such business models in order to channel savings towards other means to reach their own goals, objectives, or missions. For example, 2 particular cases before us, replacing copyright payments with scholarships or other services for students, or using copyright payments for investments in broadcasting facilities or in smaller communities. So Is this a standard conflict between buyers and sellers? Yes and no. And I'll tell you why. I'm an economist. And so what does economic efficiency or optimality tell us about this conflict?
Two characteristics. First, they are information goods or assets. I'm going to say that, which means that once produced or fixed, their use or consumption do not destroy such goods or assets, which remain available now and in the future for consumption by other people. And that will be different from the standard public goods, which have to be produced every year, like national defense, for instance, or public security. The second point is that digital technologies, what did they change exactly in terms of the world of copyright, is that they reduce to zero or almost zero the cost of reproducing and disseminating copyrighted works, whether they are music or books. And therefore, maximal dissemination becomes possible. Digitization challenges the delicate balance of creators' and users' rights. The excludability level favored by copyright may have become too severe for the digital world, hence the conflict we're facing today. Pour les économistes,
For economists, analytical solutions to this type of problem do exist and have been studied for many decades now. First best optimal allocation, the allocation of resources, would exist for that type of asset or good. Would be the price; it would equal zero for the maximum possible. But how to compensate creators in this context? The solution that economists study were second best or constrained optimal allocations, where the price would be higher than zero, in order to ensure compensation of rights holders, a compensation that would be fair and equitable. But in trying to obtain the greatest dissemination possible, or a combination of those two first solutions. In order to apply that solution or that type of solution, we have to find out the value of a product. What is the competitive market value of copyrighted works given their information good or asset characteristic and digital technologies that have changed the copyright circumstances, which make the emergence of competitive markets or the willing buyer, willing seller principle almost impossible? How to go through it? How to arrive at a solution that I called in one of my publications the Gordian knot of today's copyright world.
first, move away from the current circular heuristics in favor of direct inferences of competitive market value from the behavior and choices of users. This can be done. It is not done today. Today we say we're going to set up the rates today at that level because 2 years ago we did that, 4 years ago we did that, and therefore we're constrained by those decisions. Rights holders are significantly shortchanged by the current Copyright Act provisions, including exceptions of many kinds, and the way they are implemented. The undercompensation of creators as compared to the competitive market benchmarks is a significant impediment to a more efficient and vibrant economy. The undercompensation totals several $100 million per year in Canada.
Second policy, avoid the stigmatization of creators as the culprits in public policies towards both a digital economy and maximal dissemination through copyright exceptions, including fair dealing. Who besides creators should pay for such public policies? Example 1. In October 2012, the Canadian government issued a regulation aimed to exclude micro SD cards and similar cards from the definition of audio recording medium, therefore preventing the Copyright Board from setting a levy on such cards. The government's argument and this is a quote from a government publication, such a levy would increase the costs to manufacturers and importers of these cards, resulting in these costs indirectly being passed on to retailers and consumers, thereby negatively impacting e-commerce businesses and Canada's participation in the digital economy. And I added SIC in brackets because if Canada goes back to the Stone Age, it's because of these creators, according to them.
All major groups of beneficiaries and make them jointly and severally responsible or liable to ensure the proper, fair, equitable, and competitive compensation of creators. It can be done. There's a long list of economic publications showing how this can be done and why it should be done. Fourth, le processus actuel de...
Fourthly, the current sequential determination of royalties makes it difficult to implement significant adjustments and reforms. As I said earlier, when we decide on a tariff or royalty, we're limited because 2 years earlier, someone else decided that it made these decisions. And so all of these decisions have to be determined together and at the same time, in order to make it easier to adjust and adapt to future technological changes.
Je ne reviendrai pas étant donné que le temps...
I see that I'm running out of time, so I won't go back over the same principles, but I will just mention them quickly.
The competitive market value or balance principle, the socioeconomic efficiency principle, and the separation principle, the last one saying that it is neither necessary nor optimal that primary users' royalty payments be equal to the competitive market compensation of creators. Commercial radio, it doesn't mean that what they should be paying is what the authors and composers and performers should receive in terms of compensation. L'économie d'une politique publique.
The economics of cultural public policy are really is really the elephant in the room, alongside rights holders and users. In education, there is a separation between what consumers, those being students and their parents, pay, and what the providers of education services and content, the teachers, the school staff, receive as compensation. In healthcare, there is a separation between what consumers pay, those being patients, and what the providers of healthcare services and content are receiving as compensation, those being doctors, nurses, and health personnel. We can make that type of separation in the cultural area, but that is a fundamental aspect of the reform, of copyright reform, that we should be looking at. And I will leave you on with a certain number of references and publications in which I have further developed these ideas and which may be useful for the committee in order to better direct this copyright reform. Thank you very much. Thank you.
Of up to 7 minutes.
Thank you, Mr. Chairman. I'm not a university professor, and I certainly don't have the long list that my friends have of publications, because I've been out there actually doing this stuff for about 35 years, and that involves just about everything in copyright. You'll see in my covering letter I made a list of some of the people that I've acted for, and I've spent a lot of time at the Copyright Board, including hearing Professor Boyer and his theories on quite a few of the cases. What I want to talk about are some excuse me?
What's going on?
Maybe move your earpiece. There's feedback that's going to hurt.
Oh,
yeah.
okay.
Thank you. Apologies. So what I want to talk about today are some practical issues. I've dealt with 6 of them in my written submissions, but because of time limitations, I'll just talk briefly about 3 today. The first one is what I call the royalty penalty, and there's been a provision in the Copyright Act for some time which provides an important tool for copyright collectives. In situations where a copyright user is subject to an approved tariff but refuses or neglects to pay, the copyright collective, which is forced to take legal action, can collect, when successful in the action, can collect from 3 to 10 times the amount of the royalties. Now, the intent of this section is a really good one. Users shouldn't be allowed to refuse to pay, and then when discovered later, just say, okay, now I'll pay what they should have paid in the first place. There has to be some kind of a penalty. However, in my experience, this provision of the Act is being used far too often by collectives to threaten licensees who have legitimate disputes about how much they should pay in copyright royalties. And in my view, the use of this provision by collectives to try to coerce licensees to accede to demands by collectives, whether or not those demands are reasonable, appropriate, or justified, is unfair and certainly not a balanced approach to copyright tariffs. Now, let me just give you a very simple example. Suppose that a theater owner who puts on a musical presentation calculates that the royalty that's payable in respect of that is $1,000. Offers to pay or pays the $1,000, but SOCAN, the collective who would collect, comes in and says, oh, actually, we think it's $1,500. And by the way, if you don't pay $1,500, we're going to sue you and we're going to get 3 to 10 times the amount what we should have got. So what's the theater owner going to do? Well, he can stick by his guns and say, fine, sue me. But the risk is that if, in fact, his interpretation was wrong, which could be the case, he would have to pay between $4,500 and $15,000 in royalties when the dispute was about $500. As a result, because of this risk, the theater owner is essentially forced to exceed and pay the amount that is demanded by the collective, even if his interpretation of what was owed was correct. This scenario is not, in my view, a proper application of this section. And I should mention, by the way, that, and I mentioned this in my written submissions, that I've actually been involved in cases where this threat was made where 100 times as much money was involved. So you can imagine the amount of risk that is taken on at that time. In my view, this section should make it clear that the punitive royalty provisions do not apply where a copyright user asserts a legitimate dispute concerning the applicability of or calculation of royalties in an approved tariff, and I suggested appropriate wording in my written brief. The second issue I want to talk about is authorship of audiovisual works. Now, you've had some organizations who have appeared before you, and yesterday some organization appeared before the Standing Committee on Canadian Heritage and suggested that the Act should specify which of the creative contributors to audiovisual works should be deemed to be the author of those works. And I'm in particular speaking about the Directors Guild and the Writers Guild, who have suggested it should be hardwired into the Copyright Act that the director and the screenwriter of an audiovisual work should be deemed to be the author. Now, some copyright works, in particular audiovisual works, such as motion pictures and television shows, involve a lot of creative contributions from a lot of individuals. And so as a result, it can be really unclear who is the author of the work. Now, this is what I call a long-term problem and not a short-term problem. Because in the short term, what happens is that the producer of these audiovisual works, through contract, gets licenses or assignments of all of the short-term rights that are necessary in order to distribute the work. However, portions of the rights around an audiovisual work depend on the authorship. So, for example, how long the term is based on the life of the author. When the reversion right applies depends on the life of the author. So at some point down the road, not in the short term, not when it's in the theaters, but at some time down the road, after some of the creative contributors start to die, who is the author all of a sudden becomes relevant. And right now, that's not clear. And I admit there is a point to be made as to putting some clarity into this. And there's no doubt that the proposal by the Directors Guild and the Writers Guild puts some clarity into it. But is it the right answer? Now, in the United States, they have a fairly unique situation because they've created a thing called work for hire. And so a motion picture or television producer can get contracts from people, and the producer is now deemed to be the author. However, in Canada and most OECD countries, that's not the case. Authorship still remains unclear. And in some European countries, what they have done is they've deemed some other creative contributors to be the author, including the director and the screenwriter, in some cases the cinematographer and the score writer, and there's various other people. This again can lead to some uncertainty. Now, the question I have is, yes, while deeming certain people to be the author eliminates the uncertainty, it creates a number of problems, which I said in my written brief, but I'm just going to point out two. First, many audiovisual works don't have directors and screenwriters. And the perfect example is computer games. Computer games are very important audiovisual works, actually bigger industry in Canada than motion pictures and television, and there are no directors and there are no screenwriters. So how are they going to be authors? And the second thing is, if you're going to put in a rule like this that is contrary to the authorship rule in the United States, you really have a problem potentially with the very important film and television production industry in Canada. And you'd want to be very, very careful about doing that and jeopardizing that industry. Lastly, I want to make a brief mention about the machine learning exemption, which I'm sure you've heard about. You've had several people come before you. And I think it is really important that we have some kind of an exemption that deals with these incidental reproductions that are created by machine learning. However, in my view, if we've learned anything from the last 20 or 30 years of copyright reform, it's that having specific provisions about developing technology is not a good way to form legislation. And the simple reason for that is by the time you actually study it and get the legislation in place, the technology is off somewhere else. And you're always going to be chasing this rabbit that's always one step in front of you. So in my view, what's important is to make sure that we get at the root problem. And what is the root problem that has been talked about in machine learning? Well, it's a thing called incidental reproductions. And what happens is in technological processes like machine learning and so on, there's a bunch of these little reproductions that have absolutely zero economic impact. They're not being sold to anybody, not being leased to anybody. They have just, they allow the technology to happen. And the last time we had a very major copyright reform, we created a section called Section 30.71 entitled Temporary Reproductions for Technological Processes. And everybody thought this actually would work, that it would allow these reproductions to be done. Unfortunately, in 2016, the Copyright Board made a decision which very substantially limited the ambit of the section and in essence made it largely a dead letter. And in my submission, what should happen if we have concerns about machine learning, and we certainly should, is make revisions to Section 30.71 to bring back the robust exemption that we intended to have for these technological processes that have been largely eliminated by this interpretation. And I've given some suggestions in my written material. I'm happy to talk to you about it. But I think a revised 30.71 would better position Canada and its technological leaders for the future technologies, which we don't yet know what they are. And frankly, I can't guess them, and I'm pretty sure that most of you can't either. Thank you very much.
Thank you very much. And finally, Mr. Knopf. 7 minutes.
7 minutes. Thank you, Mr. Chairman. Good afternoon, members. I'm here also for my third time this week, as a former Prime Minister said. I guess that gives me a three-peat. So I won't repeat what I said at the Senate Bank Committee and yesterday at the Heritage Committee, but I will repeat one thing that I said yesterday, which was this. There's no, quote, value gap, end quote, in the copyright system. However, there's a serious, what I call values gap, end quote, in the fake news that's being disseminated these days about IP in general and Canadian copyright revision in particular. So today I'll talk about a few other issues and flag some that I'll include in my written brief in more detail when I submit it on or before December 10th of this year. Anyway, for today, number one, we need to clarify that Copyright Board tariffs are not mandatory for users. The elephant in the room, the second elephant today, is the issue of whether the Copyright Board tariffs are mandatory. They are not. I successfully argued that case in the Supreme Court of Canada 3 years ago. But most of the copyright establishments in Canada today is in denial or actively resisting that ruling. A tariff that sets the maximum for a train ticket from Ottawa to Toronto is just fine. We used to have such tariffs before deregulation. But travelers were always free to take the plane, the bus, their own car, limousine, their bicycle, or any other legal and likely unregulated means to do that. Choice and competition are essential, not only for users but for creators. Access copyright charges educators far too much for far too little, and it pays creators far too little. In fact, they only got an average of $190 for 2017 from Access itself and from their share of the publisher's portion. There is intense litigation ongoing now between Access Copyright and York University. It's now in the appeal stage, and other litigation in the federal court involving school boards. Unfortunately, York failed in the trial court to address the issue of whether final approved tariffs are mandatory. Hopefully, the Federal Court of Appeal and, if necessary, the Supreme Court will get this right in due course. But we can't be sure, and the other side is lobbying you heavily on this issue, including with such devious and disingenuous suggestions as opposing a statutory minimum damages regime of 3 to 10 times the amount on the totally inappropriate basis of symmetry with the SOCAN regime, which is the way it is for good reasons that go back for more than 80 years, but would be totally inappropriate for tariffs outside of the performing rights regime. In fact, Mr. Hayes pointed out problems even with the SOCAN regime. So I urge you to codify and clarify for greater certainty, as lawyers and statutory draftspeople like to say, for greater certainty, what the Supreme Court said in 2015, consistent in turn with previous Supreme Court and other jurisprudence going back decades, that copyright board tariffs are mandatory only for collectives, but optional for users who remain free to choose how they can best legally clear their copyright needs. My second point today is we need to keep current fair dealing purposes in Section 29 and include words such as, quote, such as. The Supreme Court of Canada already included the concept of education and fair dealing before the 2012 amendments kicked in. The USA allows for fair use, quote, for purposes such as, I'm emphasizing those words, such as criticism, comment, news reporting, teaching, including multiple copies for classroom use. End quote. I ask you to ignore siren calls urging you to delete the word education from Section 29 and urge you to add those two little words, quote, such as, end quote, as our friends and neighbors in the USA have had for 42 years. Number 3 point today, we need to ensure that fair dealing rights cannot be overridden by contract. In 1986, the Supreme Court of Canada, in an important but not well-known case, ruled that consumers cannot lose their statutory rights by contracting out of or waiving their rights in the case, for example, when it comes to everybody's right to pay off their mortgage every 5 years. We need to clarify and codify a similar principle that fair dealing rights and other important users' rights and exceptions cannot be lost by contracting out or by waiver. Number 4, we need to explicitly make technical protection measures, TPMs, provisions subject to fair dealing. We need to clarify that users' fair dealing rights apply to circumvention of technical protection measures, at least for fair dealing purposes in Section 29, and for many, if not all other exceptions provided in the legislation as appropriate. Number 5, we need mitigation for the nation. My friend Jeremy started using the word mitigation after the USMCA came in. And he made some good points. We need to mitigate the damage done by copyright term extension under both the Harper government, where it was buried deeply in an omnibus budget bill, heard of one of those recently, and by this government in the USMCA. These concessions could cost Canada hundreds of millions of dollars a year, and even worse now, must be given to the EU and all our other WTO TRIPS treaty partners because of the most favored nation and national treatment principles to which Canada is bound. One small mitigation measure might be the imposition of renewal requirements and fees for those extra years of protection that are not required by the Berne Convention. Number 6, we need to look carefully at enforcement issues. I know that you're under immense pressure from some very well-funded and powerful and aggressive lobbyists and lawyers on site blocking. I'm not convinced that we need any new legislation on this issue, but I am looking into it carefully and may perhaps write more about it. In the meantime, you should be looking at the existing, though not the proposed, provisions in Section 115A of the Australian Copyright Act and UK case law. We may also need to address the issue of mass litigation against thousands of ordinary Canadians who happen to be, quote, associated with an IP address that is the subject of a notice under Section 41.261A, end quote, and who are alleged to have infringed a movie that could be streamed or downloaded for a few dollars. This litigation is not, quote, akin to a parking ticket, end quote. There are systematic efforts to extract thousands of dollars by way of so-called settlements from terrified internet account holders who may have never heard of BitTorrent until they get that dreaded registered mail letter. These efforts may succeed in many cases because access to justice is very difficult in these circumstances. If the government would only do its job on the notice and notice regulations, that might be a good start. Number 7, we need to repeal the blank media levy scheme. We need to get rid of the zombie-like levy scheme in Part 8 of the Copyright Act and stop listening to the big 3 multinational record companies who conjure new kinds of taxes on digital devices, ISPs, internet users, the cloud, whatever else looks lucrative. Even the USA doesn't entertain such fantasies. Getting to my last point now. We need to stop this 5-year ritual of review. I don't always agree with Jeremy on everything, certainly not certain aspects of his study about the Copyright Board, but I do very much agree with him on this. We have had 2 major and 2 medium-scale revisions to copyright law in Canada in the last 100 years. 2 and 2 only in the last 100 years, and a few more focused ones in between. There's no need for a periodic copyright policy review. It's lucrative for lobbyists and lawyers, but it's a waste of time, including Parliament's time. And that's important. Reacting reflexively and prematurely to new technology is usually very dangerous. If we had listened to the whining of the film industry in the early 1980s, the VCR, the video cassette recorder, would have become illegal, and Hollywood, as we know it, might have committed economic suicide. Who can forget, at least some of us at a certain age, who can forget the famous words of the late industry lobbyist, movie industry lobbyist, Jack Valenti, who said, if you remember, the VCR is to the American entertainment industry as the Boston Strangler is to the woman alone, end quote. So particular issues can be addressed as needed, which is the way most other countries cope with copyright. I thank you for your patience, and I look forward to your questions.
Thank you very much. We're going to jump right into questions with Mr. Longfield. You have 7 minutes.
I'll jump as much as I can, Mr. Chair. Given the topic, it's a weighty topic, and as you've all noted, it's a difficult one for us to be addressing on a frequent basis, frequent in terms of 5 years. But I want to, something that wasn't mentioned was Article 13 in the European agreements. As we develop our trading agreements with Europe, with Asia Pacific now, the new North American trade agreement, copyright competitiveness within our region is something that I'm concerned with, of how the market works within Canada compared to other regions. Do we have some opinions on Article 13 that you could put forward for our study, for anybody?
I'll fight on that one. It's very controversial. It's very maximalist, as we say. There's no need for a snippet tax or a Google tax or whatever you call it. There's no need to put filters on what can be uploaded. This could be, to use an overworked phrase, the end of the internet. But there's no good in it. The Europeans get very maximalist very quickly, and sometimes not for anybody's good in the long run. Let's not race to the bottom of maximalist copyright protection. We stood up to them in CETA. We resisted the 70-year term and some of the other excesses. We caved into the Americans. Maybe, as Jeremy said, maybe we had no choice with that fellow in the White House. But we don't have to keep making that same mistake.
I'd like to add to that if I can.
Please.
I think it's likely to backfire in the EU. It's a terrible idea. The ostensible purpose is to force Facebook and Google and the other big tech companies, which the Europeans are, concerned about, rightly so, to force them to pay more for content. The more regulations apply in this context, actually the more it's going to entrench the powerful positions of the companies that can afford to pay those royalties and comply with the regulatory requirements like upload filters. So I read an article, it was a great article, said Google's first choice is no regulation. Their second choice is lots of regulation. And this is a terrible idea.
We've seen that in some recent comments as well. I want to thank you both for that. On a different topic, Mr. Boyer, really interested in the slides that you showed us. I was having trouble keeping up with some of the potential opportunities, but one that was really, because we don't have time in the committee to really dive into the topics, but one of the ones that really was interesting was getting all the players around the table. Something we've had problems with since the beginning of this study is to try and find out what parts of the market are working, what parts aren't working. there's general consensus that creators aren't getting paid their fair share, but is that because of copyright or not? How could we suggest in our report how to bring all the players to the table, the SOCANs and the access copyrights, creators and publishers? Who would those people be? How would we bring them together?
Yes, it's going to be difficult, to bring, because, it needs changes in different laws, I guess, which is a field I don't really all understand because I'm not a lawyer. But it's clear that if you want to implement the competitive market value of music on commercial radio as estimated from the behavior or inferred from the behavior of radio station operators, as I did in some of the publications that I showed, this would represent today something like $450 million per year in royalties. This is a competitive market value of music as revealed by the choices and behavior of radio station operators. Today, commercial radio pays about $100 million a year in royalties for music. And of course, the 350 million missing there, you're not going to ask the commercial radio operators to pay that amount, because that would limit too much the distribution and dissemination of music. And therefore you want to but how are we going to do it? Well, you have to bring the other beneficiaries, what I call beneficiaries, equipment producers, content, other type governments, as kind of collectives of end consumers, have to be sitting around the table and saying that we have to pay the commercial value, the competitive market value of music. How can we do it? Well, you have to share it between us.
So maybe in a general statement is transparency at all levels. You might not bring them into the same room, but they could have a reporting structure of some sort where we could understand where the value is being.
Absolutely.
Okay.
Absolutely.
I think part of the problem
Yes, sir.
is that there is no incentive to anyone in the user side or in the collective side or in the industry side to actually do anything but do their talking points. There
Right.
really is zero benefit to them. And this is one of the problems in the system, in the copyright board system, for example. There is zero incentive for anybody to compromise.
What
So-
would an incentive look like?
I think you have to look at other industries where people have summits behind closed doors. In this kind of a forum, nobody is going to be off their talking points. It's just not possible. If you had some kind of a summit where it was behind closed doors, Chatham House rules, nobody is able to talk about it, et cetera, maybe you'd get some real answers. But in this kind of a setting, you are not going to get anybody telling you what's going on and the transparency you're asking for.
The Commissioner of Competition has for a very long time had the ability to weigh into these issues at the Copyright Board. They've never even opened a file, lifted a finger to do that. They should be encouraged, if not told by somebody to do that. They're independent, so it's not easy to tell them what to do. Another thing might be that the Copyright Board should, either of its own motion or, if necessary, through regulations that somebody should put in place, force more transparency. They should force, for example, disclosure, sunshine laws about the salaries of senior people at collectives, about how much they spend on legal fees, and the average and median return to members of collectives on an annual basis. The board doesn't want to get anywhere near that. I've urged them to. It seems to me that should be their first order of business, because collectives are there for the public interest.
Thank you. Thank
For
you.
your multiple witnessing at different committees, thank you for all your service to our government.
Before we move on to Mr. Albus, Mr. De Beer, you had referenced a document. Could you send that to the clerk, please? Yes. Thank you very much. Mr. Albus, you have 7 minutes.
Thank you, Mr. Chair, and I want to thank all of our witnesses for your testimony here today and multiple testimonies at different committees. I'll start with Mr. Hayes. Mr. Hayes, you gave in your opening comments the example of SOCAN, where someone is putting on a feature. They say we calculate to be 1,000. It's SOCAN takes a different position, and therefore it could be 4,500, if it's 3 times what it was. So first of all, if collectives are only able to seek actual damages, won't people just automatically refuse to pay tariff as the worst punishment they would face in the first place?
As I said, I think there is a value in the punitive aspect of it if there's no legitimate dispute. And that's why the wording that I suggested in my written brief was that if there is a legitimate dispute, then it wouldn't apply. And that would be up, again, for the courts to decide as to whether it was a legitimate dispute. Very often, the way that this is used is where someone just does not pay. You have a bar or a restaurant just doesn't pay. They either don't know or they just refuse to do it, and they're hoping they don't get caught. That's not the situation I've been involved in, where you have legitimate disputes as to applicability or calculation. You shouldn't have this punitive provision being used as a cudgel by one side to try and force the other side to settle.
In those kinds of cases, then, would it not be smarter to then make a secondary regime, for example, rather than count the whole $1,500 as being, where you take that times 3 or times 10, depending, where you say it's the difference between the amount that the proprietor had suggested and the value that the SOCAN, in this case, would have said is the right amount, that $500, because to me, then again, you would see probably focusing a little bit more on actual.
That's one alternative. But the problem is there is no other regime where you, on the one hand, where you take a position, and the other side essentially is saying, okay, I've got 3 to 10 times the amount of power than you have in this dispute, right?
There is a market power, or at least in this case, I guess, monopoly power kind of.
So another alternative, would be, for example, that you wouldn't have to pay the punitive if you put up security for the amount that is said to be. That's another alternative. There's various ways to do it, but just having this penalty, and remember, it's a minimum of 3 times. The judge can't go below 3 times. It's a minimum of 3 times, up to 10 times. That just to have that there as a cudgel for one side, in my submission, is just unfair.
So, Mr. DeBeer, first of all, you've been to a number of different committees, as some of you as well have, and all of that, by the way, now is Crown copyright. So I hope you're okay with that. So we own your ideas as a parliament. I'm just advising you of this. Anyway, as a side note, though, can you describe how fair use is, as it exists in the United States, is superior to the fair dealing provisions, exceptions we have in Canada? I found your argument saying if you're going to take the worst of a regime, then you would also better complement with some of the release valves, or at least some of the best. So if you could explain that in more detail.
The reason it's preferable is essentially for the reasons Mr. Hayes gave around the text and data mining exception, because you don't have to constantly update the list of things that need flexibility, or that you need breathing room or safety valves for, rather than saying fair dealing for the purposes of 1, 2, 3, 4, 5, 6 things, which, if we look at the pattern of reform, have become increasingly specific and technical. You say fair dealing for purposes such as some of the things that we have is not an infringement of copyright. And the thing about innovation is it's by definition disruptive and unpredictable. So we talk about we want innovation, but you don't know what is going to happen. That's the point of innovation. So you can't create a list of specific exceptions to enable things that you haven't thought of yet. The U.S. approach solves that with one swipe. The argument that you hear against that position is that it's too unpredictable, it's too disruptive to settled Canadian practice. I don't believe that at all. In fact, I think we can have the best of both worlds by simply doing what Mr. Knopf suggests. It's called the such as solution. Just put in those 2 words, such as, and it would give us the breathing rooms that the Americans have to drive innovation and not stifle it.
In the last meeting of this committee, I asked about an exemption for reaction videos, for example, so that allows for people, as you said, just to put up something with their reaction to it. Do you think there needs to be some sort of carve-out for that kind of activity?
I don't think there needs to be any more specific carve-outs for particular activities. I think what we need is a much more flexible and technology-neutral approach, like fair use is. If you look at the provisions, every time that we've tried to put in these technical little micro exceptions, it backfires. And I can give you 20 years of Supreme Court cases to prove it.
So you stated before the Heritage Committee that educational authors earn virtually nothing from their works, that publishers get all the rights and obviously profits when they sell the work to academic institutions. How can the Copyright Act address this?
I think that it's not necessarily a copyright problem. It's a contracts problem. And so what I like to see is measures that the government takes requiring open access to research, for example, by research funding agencies. I think there are certain measures that you could do to reinforce the bargaining position of authors vis-a-vis publishers and other intermediaries, but it's not easily done. It's a complex issue. I think the core point is that it's not a copyright problem. That's the point I was trying to make.
Mr. Hayes?
I've been on both sides of this. I've written and I've negotiated these deals and so on. The fact is, in academic writing, the publishers have a huge advantage because the academics need to publish. So you have a very willing seller and a pretty not very willing buyer. They'll buy it or not buy it, and they're going to take most of the money for it. So it's a market issue, and you're not if you get into in the copyright reform to trying to fix the market, you go down that rabbit hole very, very fast and get into a lot of trouble.
Competitiveness, like Mr. Boyer was saying.
Exactly.
Okay.
There are potential big antitrust issues with some of the gigantic multinational billion-dollar publishers that impose these conditions. But I suggested a solution yesterday, which got some good feedback on the internet for what that's worth. But the solution came not from me, but from Roy McSkimming, who's a longtime expert who did this work for the Public Lending Right Commission in Canada. He suggested what he called an educational lending right, which would require government funding but would compensate scholarly authors like Professor De Beer and Professor Boyer, whatever, for the use of their work in educational institutions, much like we already have for public libraries, where popular authors like Margaret Atwood get up to $3,000 a year for their books being lent. That amount has gone down. It should go up. It needs new funding. But something like that for the educational realm would provide additional income and incentive for professors. And I also pointed out that professors are rewarded in other ways. I mean, if they write papers and books, they get promoted, they get tenure. Finally, they're getting decent salaries now, six-figure salaries in Canadian universities. So it's not as if they're not being paid. It's just that they're not being paid as efficiently and elegantly as perhaps they should be.
Thank you. Thank you. So we're over a bit time, but we still have time for more questions. So, Madame Quash, vous avez 7 minutes.
Merci, Monsieur le Président, et merci.
Ms. Quash, you have 7 minutes. Thank you, Mr. Chair. Thanks to all the witnesses. And I'll be asking my questions in French, so I'll just give you a chance to put your earpieces in. Some of you mentioned the issue, especially economically speaking, the fact that copyright, that the length of copyright protection should be extended from 50 to 70 years. Do you think that CD6 is going to change anything that has to do with a fair use? And yet, if so, how that's going to change? Do you think it's going to make it better to have? Will it give better access to fair use or not? Well, perhaps I'll begin. I'll begin answering. The fair use provisions. For me, of course, that has to be legally worded in order to avoid useless conflict and useless legal conflicts. Fundamentally, the economic problem underlying all this is that fair use is a form of expropriation of creators' intellectual property. The question, therefore, is how to compensate creators for these this fair use. It's according to fair use provisions, the user isn't the one who should pay for the right to use the work, but someone has to pay. So when we add exceptions, even if we add in the words such as I suggested, and other exceptions to the Copyright Act, we're still expropriating intellectual property. without compensating creators. I think from an economic perspective, the problem is figuring out who else will pay. We'll pay composers, authors, and other rights holders for such fair use. The principle of fair use is not an economic problem. It's a problem. It's a compensation problem. Someone has to pay, but whom? How have other countries dealt with that issue? Well, they have. In the case of fair use for private copying, for example, I can make private copies for my own research purposes, and someone will pay for that, whether the equipment providers, because the copy I make of any of a work for my own research purposes, or even for my own personal use, the support that I use to make that to record that copy will be paying a levy to compensate authors and composers. In France, private copying generates $300 million per year to create content creators. In Canada, that's $3 million. That's why we need more transparent practices. And I wasn't able to really elaborate on that theme, but in Canada, we have that little 2012 provision that says that micro SD are not considered as such formats. Cost $40 million, cost creators $40 million, but no one else paid for that. Thank you. Perhaps I'll ask the other witnesses to answer too. Thank you.
Professor Boyer's position, but I take a different view. I don't think that exceptions and limitations like fair use are expropriations of proprietary rights. The default situation is not that a copyright owner has the right to control every use of its work, and every time you limit that, it's an expropriation. In fact, the default is the opposite. The default position is the freedom of expression and the liberty to do whatever you want. And we provide copyright protection as an incentive to encourage investments in creativity. And to quote a phrase that the Supreme Court of Canada has used from my former graduate supervisor, Professor David Vaver, user rights are not just loopholes. And I think that's important. It's a different view of the issue.
Can I just say one thing? I use this often for students. When you think about copyright, it's an island, and the island has a bunch of little bays and little cutouts and little eddies and things in it. But the island is still the nature of the rights. The island isn't a bigger island you're cutting parts out of. So when you think of the copyright, it is the entirety of what is granted, including the things that have been carved out of it, these little bays and eddies. And so it's not an expropriation to look at an exemption. It is actually something that is a part of the grand bargain between society and creators and users.
Yes, I reluctantly, well, actually enthusiastically disagree with Professor Boyer here. Users' rights, fair dealing, are users' rights. The Supreme Court of Canada said that very eloquently and very famously in the 2004 CCH case. They're users' rights as much as right to be paid is a creator's right. They're equal and they balance each other. Professor Boyer is wrong about the $40 million cost of the SD card exception. I was very much, maybe mainly responsible for the regulation that made that happen. Why? Give me one good reason, Professor Boyer, why the SD card in my phone should have a tax on it so I can take pictures of my cat or my grandson. I mean, why does that need to go to Access Copyright or some other collective? It doesn't make any sense. Well, just because it's... Excuse me, please let me finish. So, and also there's an issue, you mentioned it in terms of term extension. I'll give you a very good example right now of why it's important to make the public domain as big as possible. In the we have a president in the United States that has everybody worried about a lot of things right now. I don't even like to say his name, but all of a sudden, a certain book by George Orwell has become very popular again, 1984, for obvious reasons. That book has long since been in the public domain in Canada, but Americans have to pay $30 or whatever for it. And the fewer of them will get access to it. It's very important to get access to the public domain as soon as possible. And even if it's not a popular book like 1984, to have it extent over protected by copyright means it's going to be harder for university students and teachers and researchers to get hold of it. There's going to be more uncertainty. There's going to be a cloud over it. It's going to enter the dreaded category of what we call orphan works, where somebody owns a copyright but nobody knows who or where to find them. So we need to get into the public domain as soon as possible. That's why I'm suggesting the imposition of formalities for that final term of 20 years.
Thank you very much. We're going to move to Mr. Graham. You have 7 minutes.
Thank you. A comment that we've heard a little bit is that 5-year revision is too often. That I would like to point out that it has the advantage of giving every MP who ever comes to the House the opportunity to talk about it. And I also wanted to follow up on a point of Mr. Alba's earlier. He commented that the testimony here is under Crown copyright. I think that's not actually the case, because we're not subject to the Crown, we're subject to the Speaker. So I'll put that thought to the analyst's head if perhaps we could revise what copyright we release our report under. Just
Read up on it.
Just for fun. Well, the start of the report is always that the Speaker grants permission under his copyright. To the chair, yeah. Anyhow, in any case, to the actual questions here. Mr. De Beer, you mentioned that 150 years is an awfully long period for copyright. I tend to agree with that assessment, although it does assume that people are producing stuff from birth to get to 150 years. So maybe only 135. What is a reasonable period for copyright, and what value does society get out of copyright surviving life in the first place?
Well, that's a great theoretical question, but as I mentioned in my remarks, I'm a pragmatist. There's an international agreement called the Berne Convention, which sets the minimum term that any member of Berne, which Canada is, can have, which is the life of the author plus 50 years. That's the international standard. That's what Canada should stick to, in my view. Mr. Knopf's idea is a great one. If we're going to extend that, there's no reason why we can't make the extension of copyright terms subject to formalities. We can't do that for the first life plus 50 under the Berne Convention, but it's a brilliant idea to make that happen for the second. And it would create all kinds of positive ripple effects, namely moving towards a registry of copyright like exists for every other kind of property right in the world, so that we can deal with the problem of unlocatable owners or orphan works and begin to treat copyright like a commodity, like the property right that it is. We can only do that if it's registered. Putting that in as a condition of the extra 20 years of protection is a brilliant idea. I don't think this committee needs to do that, incidentally, or recommend that. That's part of the NAFTA or the USMCA implementation. But you can certainly consider it.
No, that's fair. So you're suggesting that copyright should be a proactive rather than a reactive thing, so it's not an automatic thing. So, and we had one person here some weeks ago talking about the fact that their labels on their cans was copyright for life plus 70 years. Should copyright require registration to even apply in the first place, or can we do that?
We are not allowed to do that under the Berne Convention. We can impose formalities for the life of the author in the first 50 years, but if we're going to extend to life plus 70, we certainly can and we certainly should.
Monsieur Boyer, une question vite pour vous. Est-ce que votre point, c'est que fondamentalement, pas tous les...
I have a question for you. Are you saying that we shouldn't see all of these problems the same way where we're talking about copyright lengths or conditions, that each thing is different? Yes, of course. Each product is different, but the principles underlying the identification of those rights must be the same. All products are different in the economy, including the various forms of expression. When we're talking about goods that are protected by copyright. But when it comes to competitive value, a fair compensation, which for an economist corresponds to competitive compensation in competitive markets of the product in question being transacted, which should also apply to copyrighted protected services or products. Whether we're talking about an author, a performer, a producer, a composer, a publisher of novels or other printed texts, the underlying principle remains the same. I'm not sure if that answers your question. Well, more or less, yes. I have questions for all of you and not enough time to ask them all.
And something about looking at the Copyright Act in Australia as it exists, not at the proposal. What is in the Australian proposal you don't want us to see?
Well, you're free to look. They have a provision there for, and in fact, I'll send you material. I'll send it to the clerk. They have a provision there, Section 115A, that deals with site blocking, and it's fairly well balanced. I've looked at it in detail, and there's some recent case law on it. I'm trying to remember the name of the case, but I'm forgetting it at the moment. But again, I'll send the information. It requires rigorous judicial process, rule of law, fairness to the other side. The injunction can't be any longer or broader than absolutely necessary, and it's a balanced proposal. The new proposal would get rid of some of the rule of law and protective aspects of it, and allow the injunction to be a lot broader and a lot longer and a lot wider than necessary, and might interfere with freedom of expression and a whole bunch of stuff. I'm not trying to keep a secret from you. I'm just saying that the current version seems to be working really well, but that's not good enough for the big record and movie companies who always want more. And there's the UK doesn't have specific provision, but they have some. I looked at it quickly. Some reasonably sensible jurisprudence.
As
I think I tweeted this morning, the Australians have gone all in on site blocking, and they're the first country really to do it. So it's a very interesting experiment.
Democracy to do it.
Well, yeah. I mean, the Chinese didn't need to have laws to do it. So they've really gone all in, and it's going to be very interesting to see how it turns out. If anything, I would have thought most other countries would want to sit back for the next 3, 4, or 5 years and see how good or how bad it turns out, as opposed to necessarily following what they do.
How much? 40. That's enough to do this. Mr. Also, you mentioned that you'd offered to talk more about 3071 in your opening remarks. You have 30 seconds to do so.
About 3071?
Yeah.
Well, I had proposed 5 things in my written provisions that should be in 30.71, that it can involve human intervention, not limited to automatic processes, not limited to instantaneous processes. Obviously, machine learning is a technological process. These are the things that I think would necessarily be done. But frankly, the kind of proposal that Mr. De Beer is making, where you have a non-exhaustive list of fair use that mentions machine learning, mentions incidental reproductions, I would have thought would be a solution to so many of these things, and not require a specific list of things that we have to try and deal with on a going forward basis.
Thank you.
Thank you very much. And now we move to Matt, own the podium, Generu.
Great. That's what it says there. Really? Nice. Oh, all right. Well, good to be back, Mr. Chair. Yeah. Thank you, witnesses, and it's good to see the studies still being a thorough study here of copyright continues back from my previous time here. Mr. Chair, I have 5 minutes, is it? You have 5. Great, thank you.
Actually, 4.5 now.
Okay, thank you. Do you want to come back to your comments, Mr. De Beer? I'm still struggling to understand why, regardless if it's 5 years, 10 years, in terms of the mandatory review, because I believe in, and what I feel what we're trying to accomplish as a committee is to look at the long view of what we don't. We're trying to project what we don't know is essentially determined in copyright. So there's so much in terms of technology. The last 5 years, the things like Twitter and social media weren't to the extent they were today. So in terms of, I've always supported the 5-year review, but you raising it, has me, I guess, a little confused and also questioning it somewhat. So in terms of reconciling that the new technology piece with not doing a review at all, I guess just help me out a little. Maybe Mr. Knopf, since you hold the same position, if you could also comment on some of that.
One of the problems is that it takes away some of the responsibility to create a technologically neutral act in the first place, because people think, oh, well, we can just fix it again. We'll reopen it 5 years later. That's one problem. Another problem is that it's very politically expedient. I get it, right? Everybody's coming here. There's 182 witnesses. They all want something, and you can't give everybody everything they want. So it's very nice to say, oh, but come back in 5 years. We'll talk again, right? So it's very politically expedient, but it just means everybody lines up every 5 years and asks for the same thing. And I mean, I've been around this for only 15 years, not as long as some of my colleagues here, and really, like, it's tiring. It's just the same debate over and over and over and over again. It's not very helpful. So I think those are really the main two problems. That it's a disincentive to draft technologically neutral principles in the first place, and it just gets us on this constant hamster wheel of lobbying. So I'm not saying the act doesn't need to be reopened, but every 5 years. Oh, sorry. And the other part about this is we don't even know. The implementation of the last reforms is just working its way through the court. All of the regulations to like tie up the loose ends from the last batch of reforms aren't even in place yet. There was a Supreme Court decision in the last couple of months dealing with the notice and notice provisions. So it's just too soon. We don't know if things are working or not working yet.
So sorry, Mr. Knopf, just before
Yeah,
I go to you. Just follow up on some of that quickly. The YouTube exception, for example, it came out of the last review because YouTube was a new thing, if you will. Who knows what 5 years from now brings? So in terms of not reviewing it, it would I feel then how do we react to that? Are you saying we put in draft legislation when those exceptions come up? Because then I worry that then there's other impacts on certain things that we may or may not know what those things are.
Well, the YouTube exception, the user-generated content exception, the text and data mining exception, all of these micro exceptions for libraries and archives and museums. I mean, all of this would be unnecessary if we just put two words in the act, such as. It's a much simpler solution that'll stand the test of time.
Sorry, Mr. Knopf. Go ahead.
Yeah, there's an old song. I won't try to sing it. The fundamental things apply as time goes by. Casablanca. It's in Casablanca. Some things just don't change. Even since the first Copyright Act in 1709, certain principles don't change very much, and they certainly don't change very quickly. And it's like I said, it's a really bad idea to try to get ahead of things in the interests of being smart and tech savvy. And like I said, if you had listened to Jack Valenti, Hollywood might be, as we know, it might be dead if his own industry had listened to him. So it's a big mistake to try and react quickly to technology because these things don't really change. The details do, and the market sorts it out. And the best Copyright Act the world has ever seen was the 1911 UK Act, which was really short and very general and really simple. Thank God Canada still has the skeleton of that. The UK has gone off the deep end with details. The UK judges hate it. Everybody hates it because they move too quickly too often. Actually, working on this VCR case was the first thing I did when I joined the government as an analyst back in 1983. Wrote a paper as to why we don't need legislation. I'll leave you with one other example. In 1997, I believe, or maybe it was 88, no, I think it was probably 97, some wise bureaucrat over at Heritage inserted an exception in the Copyright Act called the dry erase board exception. So it said that it was okay for a teacher to take a chalk or a marker and write on a dry erase board by hand as long as it was then erased with a dry instrument, okay? And I did a sarcastic piece in the newspaper, and the cartoonist showed a janitor using a wet brush and questioned whether that was infringing. Mercifully, that frankly stupid exception has been gotten rid of, but this shows the level of detail that people can get involved with all the best intentions that is completely counterproductive. So again, I'm happy to agree with Jeremy on this.
Thank you.
I think, I don't know whether I was trying to find the quote, Winston Churchill or somebody.
Way over.
Said, official came to him and said, Prime Minister, we have a terrible crisis. I must speak to you today. And he said, if it's still a crisis, tomorrow come back and we'll talk about it.
Thank you. Thank you. We're going to move to Mr. Johari. You have 5 minutes.
Thank you, Mr. Chair. I'll be sharing my time with Mr. Lametti. On the 2.5 minutes that I have, I really like to go back to Mr. Hayes. Mr. Hayes, you, in your testimony, you indicated that there are 6 issues that you wanted to talk to us. You highlighted 3 of those, and then you run out of time. So with all my other questions being answered, I would really like to give you 2.5 minutes or 2 minutes to be able to highlight those 3. I know they're a part of the submission, but it would be good if everyone can benefit from it quickly. 2 minutes.
Sure.
Thank you.
The first one is the charitable exemption, and you had some submissions by, I believe, SOCAN and perhaps some others regarding limitations to be put onto the charitable exemption. The charitable exemption has been in our Act for almost 100 years. The only major litigation about it was in the 1940s, involving Casa Loma and concerts they put on and this kind of thing. I represent a number of charities who operate under the charitable exemption, and the reason they do is not because they're charities registered under the Income Tax Act. It's because their charitable charter specifically says they put on musical presentations. That's what they do. And so the charitable exemption is specifically intended to deal with their activities. And yet SOCAN has continued to argue that, oh, no, it doesn't because of these restrictions, which they claim are implied, and now they're asking you to put in. And in my submission, there's all sorts of things. Musical programs, symphonies, church and school groups are all going to be very seriously hindered if that change is made. My friend Bob Tarantino came before you and talked about reversion of copyright and suggested taking out the reversion provision. I know Bob well, and
Quickly go through the other 2 because you
reversion of copyright. He just says you should take it out. I don't see any reason. The only reason he really gives is the uncertainty, and the uncertainty comes about because of the life of the author. Right, so it's life of the author is uncertainty about term. It also makes the uncertainty about reversion rights. You're not going to get away from that, and I think it's a widows and orphan provision. It's for those authors and artists who didn't get the money they deserve, mainly because of bad contracts or they weren't recognized in time. And after they die, there's a chance for their widows and children to be able to take the copyright back after a period of time. And if there's still value, they can earn it. And I don't think anybody has pointed out any real reason why that shouldn't happen. And by the way, this is a tiny, tiny proportion of copyright works that actually have any value by the time the reversion right comes up. And so it's actually done in a tiny, tiny number of situations. And the last one is about the definition of sound recording. I'm not really even going to get into it. I went to the Supreme Court on it. We won at every single level. It's clear what the statute was intended to do. There's a business reason for it. I invite you to go back and look at what the Supreme Court of Canada and everybody else said about it. There is absolutely no reason to change the provision except for the fact that the sound recording owners, in other words, the record companies, would like to get some more money. And
Thank you. Over to Mr. Lametti.
Thank you. Mr. Hayes, just on, we've heard a number of different ideas on machine learning or data mining exception, ranging from such as to your point on incidental reproductions. Do you think that your idea catches, say, the use of a particular piece, a pool of data, in order to, draw out the numbers and do some other sort of analysis?
Yes, I think it does, because you have to remember what is being asked for is not the right to be able to use every piece of copyright information or data or whatever, because I think all of the submissions have made it clear they're only talking about legally acquired copyright material. So they've gone and bought or licensed a copy of the books or the magazines or the movies or whatever. What you're trying to get away from is the copyright owner saying, oh, the machine reading the book, listening to the movie, watching the television show, looking at the photographs, which they have to do by making an incidental reproduction. There's no other way for a machine to be able to learn those things. That is a copyright event. We should be paid more in addition to the original purchase price or license price for the copyright work.
My concern is in the use and the transformation in running the data through, that there might be a claim that the use of it, not necessarily the copy of it, would fall under the ambit of
it doesn't seem to. I mean, there isn't. Remember, the copyright is a bundle of rights. So in order for there to be a copyright event, you have to have done one of the rights. So me reading a book is not a copyright event. And so absent the reproduction part, there should be no reason why a machine reading a book is a copyright event as well.
All
Right? Time's up.
Mr. Albus, you have 5 minutes.
Mr. Hayes, just on going back to the charitable exemption, look, if you have a major festival that's charging big dollars for people to come in and to hear a musician that may be using someone else's work, and then to surround that with an exemption that it's charitable purposes. I don't know about you, but at least where I come from, charitable purposes are about feeding people either their minds or their stomachs. That's, when people are utilizing, it's large amounts of money in some cases, because some of these festivals can be, or might be paying someone $100,000 to come in and to put on these productions.
That can happen, but it's relatively rare. I mean, in most cases for these kind of charitable things, you get a lot of the performers are contributing their services as well. But yes, it's true that there are costs.
Proportionality, though, where again, there should be some sort of formal test, and not just, and someone just can't say, well, I'm doing this for charitable purposes.
Well, there is a formal
when there's
test.
no one other than the people that are attending that pay for the tickets.
But that's what I'm saying. There is a formal test, and the test came out of the Supreme Court of Canada case back dealing with the Kiwanis Club in Casa Loma. And the reason that the Kiwanis Club lost and had to pay royalties is because their charitable charter said nothing about putting on concerts.
Yeah,
that wasn't what they were doing.
Yeah, but isn't it our job though also to look and see, what kinds of behavior are appropriate and what's not, and then to set the law. Court may have at least captured within the context of that particular case. But again, I do just want to push back and just say that not all charitable purposes are equal, and not all festivals are equal. There's a large difference. I would hope you would agree with that.
Well, and I think this is a hard thing to capture. I mean, if you look at some of the or you look at some of the charitable organizations like the Royal Conservatory of Music, it is absolutely impossible if you look at what they do between the educational aspect and the presentation aspects and so on, that they aren't serving not only a charitable purpose, but an important purpose in society and in the community. And that should be supported. And I can tell you that if they were paying the same amounts as commercial producers, they would not be able to provide all that they do.
I would just say, though, again, if someone is running something similar or akin to a commercial enterprise, there should be some questioning of whether or not it's a charitable purpose. I'm going to go to but thank you for your comments on Mr. DeBeer. Now, going back to the issue where is it a problem with contracts versus a problem with copyright, you've come clearly and said that a lot of this is onto contracts. But, as you said, every time there's this 5-year review, everyone comes out and says, we have a problem here because we don't like the common denominator or the contracts we've signed. So, what can we do to address this problem, or is this something we just simply say if people make a bad contract, they have to live within those contracts?
Well, I think the law of contracts provides one outlet where contracts are unconscionable. I think that we can do more on a policy level to support artists and authors in their negotiations with record labels and publishers, but that's not through copyright. That's activities the Department of Canadian Heritage can do outside of the copyright regime. We don't need legislative reform to do that. I think one of the best things that we can do, actually, and I've written about this, is create a certification scheme, a certification mark. And someone's picked up on this idea and created fair trade music so that consumers can make informed decisions where artists are fairly compensated. Consumers can patronize those businesses that are certified to be fairly compensating authors and creators. So lots of examples that we can do, but it's just not a copyright problem.
Okay, no, that's fair enough. So again, we're discussing Crown copyright. To me, I don't see this as being as big an issue, whether it be the Parliament of Canada or the Government of Canada. From what I've seen from some of the briefs we've had, is it seems to be courts, certain courts, I should say, not all of the same, and their reporting functions, and some provinces. So, for example, if a company is trying to set up whether it be federal or provincial chatbots to talk about what labor laws obligations that someone might have, where you might talk to whether it be an AI or some sort of, you might insert the problem into and receive an answer because there's so many regulations now. If someone tries to draw in provincial law or provincial court cases and either can't attain that information or is sued by the Crown, and it is, again, the Crown, it's a reserve power of the Crown, that would be at issue. So how do we get past this in a way, because we have many different entities that may take a different approach?
I would like to see us abolish Crown copyright. I'm not going to sit here in light of what I said earlier about, not giving everybody their ask and giving everybody what they want. I'm not asking you to do that, but if it was up to me, I'd just abolish the whole section. I would note that there's a Supreme Court of Canada case coming up. The hearing has just been moved. I got news to February. It was supposed to be in January. I'm acting for the University of Ottawa Centre for Canadian Internet Policy and Public Interest Clinic, CIPIC, in that case. We're filing our written submissions next month. And so the Supreme Court of Canada, sometime in the next 3 to 9 months, will issue a ruling on the interpretation of Crown copyright. And depending on what they say, could either solve the problem or exacerbate it. So I kind of have to reserve judgment on the Crown copyright issue until we see what the Supreme Court says.
Thank you.
Are we continuing to consider this, or should we wait for the court case?
You could abolish it or wait.
Thank you. I hate to be the Grinch, but we do have to be out of here by 5:30. So, Mr. Sheehan, you got 5 minutes, and then Madame Quash, vous avez 2 minutes, and then we got to go.
Thank you, Mr. Chair. Thanks to our presenters. So, since the beginning of this study a while ago, there's been a number of proposals from Canadian creators, amendments, if you will, that would directly benefit them. And some of them, I just wanted to get your comments on that have been proposed to us. We'll start with the first one, was the resale right on visual works of art that allow the creators to receive a percentage of every subsequent sale. So the painter, if you will, the next sold and sold and sold. Granting first ownership of cinematography works to directors and screenwriters as opposed to producers. I think someone touched on it briefly. A reversionary right that would bring the copyright over a work back to an artist after a set amount of time, regardless of any contracts to the contrary. And granting the journalist a remuneration right for the use of their works on digital platforms such as news agitators. We heard from Facebook at our last session about that, and they had some comments about it. So would you endorse these kinds of ideas? Do you think they would benefit the creators as opposed to right holders more generally? And also, what could be any unintended consequences that these proposals would have? So there's 4 of them. I only have 5 minutes, so maybe if Jeremy, Mark, and Howard each kind of want to take a little shot at one of them.
I talked about 2 of them in my presentation already: the reversion right and the second one, the cinematographic works. So I don't really have much more to say on those unless you have specific questions. But I think both those proposals don't make any sense.
Brian Adams, I believe, actually suggested moving the reversionary right back to 25 years after the contract was signed. And he had Professor Daniel Gervais, formerly of the University of Ottawa, quite a brilliant guy, who's now at Vanderbilt. That should be given serious consideration. As the resale right, it's a rabbit hole that I don't think Canada should go down. It's great for the auction houses. It's maybe in some ways it'll complicate the art market a whole lot. And the art market has flourished very well for thousands of years without it. I don't know why we need it now. Some countries have it, and it arguably is ruining the art market in those jurisdictions. The other things that you mentioned, I don't remember them all. Many of them are just opportunistic, I think, and more rights are not necessarily better. I mean, chocolate is good for you, wine is good for you, maybe even vodka is good for you, but all of those things in excess can be very bad for you, and maybe even fatal. So,
is the granting the journalist remuneration right, and it's come up a few times by in different testimonies.
Again, journalists should be well paid. They do very important work, but just because something, if somebody writes for the Toronto Star, they're getting paid a salary. Now, just because it shows up on the internet doesn't mean they should get paid again.
That's the Article 13 issue and the link tax and the upload filters. It's going to backfire if we do it. We should absolutely not do it. The other things are a tempest in a teapot. I mean, do whatever you want. It doesn't really matter in the grand scheme of things. Not like it's a different, or the problem is a different order of magnitude than the link tax issue. Same thing with site blocking. You've heard a lot about site blocking. I think it's a terrible idea to do it in the Copyright Act. The provisions already exist in the Rules of Civil Procedure. They've been well used. People say, well, it's hard to get a site blocking injunction. It should be hard to get a site blocking injunction. It's an impediment of free expression and commerce. And most importantly, if you can't get it for, say you're a victim of revenge porn, you got to go through the usual processes. Why should copyright owners be treated any better or differently? So it already exists outside of it. Those are the two big ones that I think you got to really worry about.
Talking about some of the newer technologies that popped up in the last 5 years, there's been a lot of testimony about Spotify and how Spotify functions. And a lot of the artists are pointing out that the music industry's revenue as a whole has exploded. And all the data will show that because of things like Spotify that replaced your bear shares and all those other illegal activities. But also the creators, what they're making, Canadian creators, are not, in their opinion, and they have data to suggest that it's not keeping up at the same rate. Any suggestions on how that might, either through copyright or other means or other mechanisms, how that could be resolved?
Well, the Copyright Board, as I said, should be more intrusive. They should force these collectives and parties to be more transparent about their internal operations and how much money is actually getting through to the creators. They should not allow a collective or a corporation to operate with a Copyright Board monopoly if that outfit is not behaving fairly. And the Competition Commissioner should get involved, which they've never done, but they have the power to do that. So that if there are some giant, huge companies out there now that are now in hindsight making Microsoft look like an angel, that require antitrust scrutiny.
Thank you. Thank you. Sorry, we are down to the wire, but what I will say is if you'd like to answer that question in writing, please send it to the clerk. We have 2 minutes left. Madame Quash, it's all yours.
Merci, Monsieur le Président.
Thank you, Chair. My question is for Mr. Boyer with respect to defending art, standing up for artists in particular. The issue of copyright on the internet. My question has two aspects. There are there's a lot of uncertainty and costs associated to defending one's rights when it comes to one's work being used on the internet. So firstly, it's difficult for an artist to get compensated. At the Heritage Committee 2 months ago, we heard from David Bussière from Alpha Rococo, who is a performer and a composer. And he said that for a song that played 6,000 times on the radio, he received over $17,000 in royalties, whereas on Spotify, 30,000 people listened, and he got $10 in royalties. So how can we counter that problem? And on the other hand, on other platforms, let's see that paintings, for example, see their works on a platform and then they show up somewhere else. So how can we help these artists? Well, I don't know how much time I have, but even if it's only 30 seconds. Spotify and commercial radio are two completely different technologies, and the way they calculate royalties is very different as well. One of the reasons for which Canadian artists are poorly compensated on streaming for streaming technologies is because the Copyright Board based its calculations on commercial radio. So they tried to estimate the audience size and so forth in its formulas. And since the determination of commercial rights, royalties for commercial radio are not a competitive, that's not a competitive market, that doesn't meet the requirements for the definition of a competitive market. Well, of course, all of that was also transferred to the streaming world, which was bad for composers, authors, performers. So when I mentioned that one of the changes that needed to be made was to avoid that kind of establishment of rights in a sequential manner where previous conditions are affecting the way you deal with current conditions. And so the streaming area, unfortunately, to the detriment of authors and performers, composers and performers, the Copyright Board was led into a bad decision. I'm sorry, but the chair is telling me that I have to stop speaking. Oh, I'm sorry, I just have no choice. There's another committee that's coming to use this room right now.
questions that we didn't get through, please send them in to the clerk. And I want to thank you all for being here today. It was another great session, and we're adjourned.